prayer we do make outside this is this, that we cannot have, whatever the outcome of this petition, we cannot have the self-discredited person who is giving false affidavits and doing all these things to be the chairperson of the IBC or anything at all. And so we are also saying that there are two prayers in relation to this. The Article 3 of our Constitution says this. Article 3, sub-article 2. And this is at the heart, I pray, of the judgment that this Honorable Court gives. 2, any attempt to establish a government otherwise than in compliance with this Constitution is unlawful. Any attempt to establish a government otherwise than in compliance with this Constitution is unlawful. And so, in what is a 34C? A 34C is what leads to 34B, which leads to the declaration of a precedent, which is the formation of a new government. That is what was going on the 15th of August there. An attempt, and even here, right now in this court, there are people who have filed things in contravention of the Constitution, saying that what is in contravention of the Constitution is correct. And right here in this, there is an attempt to establish a government otherwise than in compliance with this Constitution. It's unlawful. So, if this Honorable Court finds that Mr. Chebukati is responsible for and has committed actions and decisions which are an attempt to establish a government otherwise than in compliance with this Constitution, we pray that you make a holding
documentary crew, and I asked Helen, how do you
that
do that?
He has done such an attempt.
The Silva technique. Helen, you see, was Jose Silva's former
which
PR manager.
is a mechanism within the Constitution itself and within this election petition's four corners, and a second and another one, another declaration that this person, pursuant to Article 33, sub-Article 2, is no longer fit to hold public office. We go further. Is it possible that we can stop it by stopping Mr. Chebukati alone and we submit? No. It doesn't matter whether Mr. Chebukati will find another Mr. Chebukati next time. We have to stop those people who do not take those steps, but who take the benefit of those steps. And those people who take the benefit of the steps which the Constitution itself says is unlawful cannot take public office on the basis of a false 34C, 34D, of a declaration made by a person who knows he's made it falsely, so that we also pray that those who seek to benefit from the wrongdoing of Mr. Chebukati are themselves caught by Article 3, sub-Article 2, and you have the powers to make the same orders, that they too are making an attempt to establish a government in Kenya otherwise than in compliance with this Constitution. And we pray that this court moves our country forward with those two steps of orders in relation to all parties benefiting and all parties carrying out this mass attack upon Kenyan democracy. Thank you. To all parties benefiting and all parties carrying out this mass attack upon Kenyan democracy. Thank you. To all parties benefiting and all parties carrying out
I pray
this
to the court
mass
to allow
attack
me to say a
upon
few things in
Kenyan
conclusion.
democracy. Thank you.
And,
to all parties
honored to
benefiting
come after
and all
my
parties
senior.
carrying out
I pray
this
to the court
mass
to allow
attack
me to say a
upon
few things in
Kenyan democracy.
conclusion. Cannot
Thank you.
and
to all
record
parties
honored
benefiting
that in
and all
1990
parties
I
carrying
filed
out
I pray
this
to the court
mass
to allow
attack
senior counsel
upon
challenging the
Kenyan
election
democracy.
that cannot
Thank you.
and
to all
record
parties
honored
benefiting
that in
and all
1990
parties
I
carrying
filed
out
I pray
this
to the court
mass
to allow
attack
senior counsel
upon
challenging the
Kenyan
election
democracy.
that cannot
Thank you.
and
to all parties benefiting and all parties carrying out
I pray to the court
mass
to allow
attack
senior counsel
upon
challenging the
Kenyan
election
democracy.
that cannot
Thank you. to all parties benefiting and all parties carrying out
that
this
what
mass
has
attack upon Kenyan democracy. Thank you. all parties benefiting and all parties carrying out
that what has evidence which has not been controverted. For example, there is evidence of interference which has not been controverted. For example, technology infrastructure of IEBC and the evidence of Mr. George Njoroge, which was covered by Mr. Morgor. I want the court, with respect, to look at what which was covered by the IBC has said in return or in response to those very, very serious allegations. To look at what through Mr. Martin Wachira Nyaga again was referred to by Mr. Morgor. He does not deny the disclosure of the 6 logs was referred to. Evidence actually acknowledges the logs which speak to access to the servers without authorization. And he puts the question the other way around. Instead of this matter to the servers going into inquiry by the Electoral Commission, he questions the authority of Mr. Njoroge in accessing or in obtaining those logs. And he says the same things about the logs that have been put forward by Mr. Justice Nyangaya. The authenticity and integrity of those logs have not been rebutted. We are treated to an explanation the authenticity in the affidavit of Mr. Wachira of those logs, in particular about the generation of Form 34. An explanation, and those rebuttals do not answer the question as to why there are these unauthorized access to the servers of the IBC and obtaining those particular logs. There is also in the bundle, in the evidence through the affidavit of Mr. Nyangasi of those particular logs. 34, two Form 34 Cs, one generated on the day the results of the elections were declared on the 15th of August, and the one that was generated on 31 generated on August 2022 is based on the results obtained at the county level. The next day, again, another Form C was generated. All that is in the bundle of Mr. Nyagas. Another Form 34C. That one, the next day, was computed on the basis of the results that were obtained from the polling stations. So we got two Form 34Cs. That one, there is no explanation given as to why there was those two forms. So, Your Lordships, we pray that the orders that we prayed for are justified. But probably in future, there may need to be a thorough inquiry as to what happened. Not just looking at the question of whether Mr. Ruto was validly elected, but looking at the criminality that characterized this entire enterprise. And that is when the Kenyan people will know the truth. But for now, I think the Kenyan people will be happier if this court can make sure that the authority, their sovereign will, is not taken away. I thank you.
Thank you very much for keeping time. We will take one more before we break for lunch. Petition number E001 of 2022, John Njoroge Kamau.
My lady.
I request for indulgence of the court just to introduce three people I'm appearing with, but they were in the other room, they didn't get access to court. And that is Emmanuel Bitter, Christopher Marwa, and Radhika Arora. I would like to put them on record. Thank you.
Thank you. That is noted. Of 2022, John Njoroge Kamau.
My lady, Madam Chief Justice, my lady, the Deputy Chief Justice, my lords and my lady of the Supreme Court. I don't believe I need to introduce myself again, since I did that right at the beginning. But all I wish to state is I appear for the petitioner,
I request for indulgence of the court
John,
just to introduce three people I'm appearing with.
Mr. John Njoroge Kamau, who has been called as a surrogate in some of the affidavits, and unfortunately yesterday was called a proxy.
That is noted.
My ladies and my lords, Article 1 of the Constitution relates to the sovereignty of the people. Article 3(1) of the Constitution, it is the duty of every Kenyan, Madam Chief, Madam Chief Justice here, my lady, the Deputy Chief Justice, to uphold and defend the Constitution, my lords and my lady of the Supreme Court. Hence, it is very sad to see. I don't believe I need to introduce myself again, or in this case, since I did that John Njoroge Kamau, but comes to all court. I wish to state is I appear for the petitioner. He is immediately vilified and stigmatized. All he is doing is exercising his constitutional duty, who has and been following the law, as a surrogate, never wanting to go back to where we went. And unfortunately, yesterday was called a proxy. And like I said, in social media, everybody gets vilified. And my lords, don't need to read social media, as I was told 10 minutes ago. Relates to the sovereignty of the people. Same, Article 3(1) on the 9th of Constitution, it is the duty of every Kenyan, in exercise and most of his constitutional Kenyans, to uphold and defend the Constitution. Hence, it is very sad to see that when Wanjiko, or in this case, comes to court, Njoroge Kamau, he or she is immediately vilified and stigmatized. All he is doing is exercising his constitutional duty and following the law. never wanting to go back to where we went about 15 years ago. Not, and like I said, in social media, everybody gets vilified. Don't need read social media, as I was told 10 minutes ago. Notwithstanding the same, George Oroge Kamau, on the 9th of August 2022, in exercise of his constitutional right to vote under Article 38 of the Constitution, went to his polling station to vote for his preferred presidential candidate, and then went home to await the result. It was a long wait for 6 days, but that is not his gripe at all. He is not complaining about the 6 days. As far as he was concerned, he had this legitimate expectation there was going to be a free, fair, credible, accurate, transparent, and verifiable election pursuant to Article 86 of the Constitution. But my poor client, lo and behold, to his shock and horror, at about 4 p.m. on the 15th, a public statement was made by Juliana Cherrera, Irene Masset. Lo and behold, to his shock and horror, Justice Nyangaya and Francis Wanderi, and I will call them as the 4 commissioners because I won't continue to repeat their names. And in that statement, before the declaration of who he wanted to know was his president, before that declaration, they came out and stated that this election was opaque. Subsequently, at about 6:05, the chairperson of the IEBC declared a result to say who the president-elect of the country was. And this was duly gazetted. Subsequently, at about 6:05, to confound it all, on the 16th of August, people started calling, and the 4 commissioners started calling this the Chebukati's results. On the 17th of August, 2022, a statement was issued by the chairperson of the IEBC. And I'm not going to get personal here. I will call him by his title that he's got at the moment, stating the reasons why the 4 commissioners, and the drama continues. My ladies and my lord, this is a voter who is watching all this unfold in public. His simple question is, did my vote matter? Or was it Chebukati's result? Or was it an opaque result? What happened? And that's why that's who I am representing. And I'm very curious for myself. Where did my vote go? Did it go anywhere? Or was it not there? Was it an opaque result? What happened? My lords and my ladies and my lords, and I'm very curious for myself. In order to meet the constitutional threshold of being a credible, transparent, verifiable, accurate process, the electoral process must be conducted in strict compliance of the law. We have filed on behalf of the petitioner very extensive submissions. These were filed on the 26th of August 2022. I am caught in a position where I could sit here and reread everything that's been said or everything that has been reiterated by my learned seniors who are, for once in my life I can say who are much older than me, because normally I'm one of the oldest people in a room, who are much older than me. So I don't wish to repeat everything that they have said, because that we don't have the luxury of time. I will just keep it very, very short, because I am sure your ladyships and your lordships will read the 23-page submissions that we have done. 1. Under Article 138.3 of the Constitution, it specifically states that after counting the votes at a polling station, IEBC shall, it is not say, may, shall tally and verify the count. That's what our framers said. Article 138.310 now starts distinguishing. It says the chairperson of the IEBC. That's what our framers said. As yesterday was said by Madam Chief Justice, the framers of the Constitution decided to give you 14 days. It's not easy to complete this election petition. It's got to be done within 14 days. The framers of the Constitution knew exactly what they were doing because of where we had come from, culminating in 2007. Hence, the declaration was to be done by the chairperson, but the verification and tallying, if they wanted to do it by the chairperson, they would have said it. Secondly, if, as is being stated by the chairperson of the IEBC, as he's put in his statement that was issued on the 17th of August, it is me. It is me who has to verify and tally pursuant to regulation. There's a regulation 87.3, which my learned friend Mr. Feroz now took your lordships and your ladyships to. I can do it. If he could do it, why wasn't it said? And if he says he can do it, why do you need a commission of 7 people? Why do we spend so much money, taxpayers' money, on a commission of 7 people? Have 3? This court has ruled that 3 people constitute a commission. Have 3, why do you need 7? Let's take it further. If it's only him, and according to some of the submissions and arguments that are going to be placed before you, the issue of Schedule 5 regarding quorum, and that he doesn't need quorum, it's only in the normal business. My ladies and my lords, what exactly does the IEBC do? Voter registration, but what is its main function related to? Elections. It is all about elections. That's what they do. I don't believe there's been much boundary delineation, but I will stand to be corrected on that by my learned friends on this side. They may know a little more than that. And so, if it is only the chairperson whose argument is there is 34A, so there is an announcing declaration there, then there is the polling center, and then it comes to him at the tallying center, and he does it. I still go back to 30 billion shillings on an election, and this is what we've got. It's a very sad state of affairs we are in. One man, let's have a commission of 3, going by what he says. Taking it now to the regulations that he relied upon on the 17th, with your lordship's permission, I would state those regulations, unfortunately, when your ladyships and your lordships decided, as my young associates say it in my office, I don't know how they do it, but they say it, Raila and another versus the IEBC of 2017, they claim that according to terminology they use, it's called Raila 2, and then the subsidiary one, the second one that came, when it came for clarification, they call it Raila 2.5. So I don't know why they do that, but that's what the young lawyers do, so I'm going to use their terminology. When Maina Kiai was decided, and this particular Maina Kiai was decided I believe it was I'd written the date down, but Maina Kiai was decided in June 2017. Subsequently, the chairperson of the IEBC came to your lordships and your ladyships asking for a clarification as to exactly how Maina Kiai was interfering with your decisions in Raila 2. It was so clear on what this court said. And the saddest part is regulation 87 that he is relying upon was not brought to your attention, and from 2017 to 2022 All IEBC does is hold elections but doesn't look at its regulations? And are these regulations, are these going to be the mundane matters that the Commission has to decide? Because we've been told, besides verifying and telling, the Commission does everything, and those are in their submissions. My lords and my ladies, if you look at my written submissions, and I'm going to take you through them very quickly as to, if you look at, and this is, the page numbers are verified, the case numbers, we've put in a bundle of documents. What that statement of the 17th of August said, please, if you could look at page 8 of my written submissions, at paragraph 19 from about line 18. And this is a quote from the Maina Kiai case. It is, in our view, fallacious and flies in the face of clear principles and values of the Constitution to claim that the chairperson of the appellant can alone, at the tallying center or wherever, purport to confirm, vary, or verify the results alone. This honorable court further said the same thing in the RILA 2.5, which is set out at page 11 of the submissions at the bottom. And you go to page 12, this is at paragraph 20, and it will be paragraph 292 of the RILA 2.5. The failure by the first respondent, IEBC, to verify the results in consultation with the second respondent, IEBC chairperson, before the latter declared them, therefore went against the expectations of Article 138(3)(3)(c). And there are several quotations I have put in there that show that this court has already made the decision. My biggest fault with the IEBC, and it's not particular the chairperson in himself, for 5 years you did nothing. The Supreme Court told you in October 2017, you can't do this. You do nothing. You amend in April 2017, you leave it at that. There's been hardly any amendments. It doesn't matter who's the Kenyan voter. IEBC, chairperson, we own this. It's an independent commission, but they have to work within the ambit of the Constitution. My ladies and my lord, I'm just going back now. Like I said, I have 15 minutes, and I think I'm going to be at a space where I'm going to be a very patriotic Kenyan, and I'm going to donate the time back to the court, because I don't think I'm going to take the full time to finish my submission, because it's fully set out where we are going to. There are three things that we've brought up. One is the issue of the regulation 87, which has to be made unconstitutional. And we have relied upon the court, the judgment of this court in the case of Rai, where you declared section 14, where Parliament went way beyond the ambit of what this court was supposed to do. We are relying upon that to declare that, because it appears IEBC is never going to come to you, so we might as well do it once every 5 years to see where they've got it wrong. We're requesting you to declare it unconstitutional. We are going further and stating to your lordships, to your ladyships and your lordships, the issue of the elections, of the cancelled elections. Whilst the elections were cancelled in counties or gubernatorial, and an issue has been taken up that if this court has jurisdiction, because interpretation of the Constitution is in the High Court. My ladies and my lords, Article 101 actually gives a date cast in stone when our elections are going to take place. General Assembly, Parliament, Presidential, the whole lot. So it is on the second Tuesday of every 5th year. Article 101 read with Article 136(2)(a), read with Article 177(1)(a) of the Constitution, and 181. Clear, cast in stone. We all know why that happened, because initially dates could be set by whoever they wanted to. And you could have a date on the 29th of December for an election where voters were available or not available. That was the history of that, in a very narrow way. We now have a situation where elections were cancelled. Today, we have a chairperson and an IEBC who are so disconnected. What happens if in 5 years from now, somebody decides to cancel a presidential election on the basis of a national emergency? This is something that really struck us when we were looking at this. It was something that had never crossed our mind. It's a hypothetical, yes, but maybe some direction needs to be given on that. Secondly, the suppression of voter turnout and voters being disenfranchised. We've been told this entire election is mathematical. Take a calculator and you'll get a result. That's what I've been told. If it's as simple as taking a calculator, the national tally that was stated by the chairperson was 65.4% or thereabouts. In Mombasa, where there was no gubernatorial election, and that you can work out from simple mathematics as to the number of people who showed up vis-a-vis the number of people, the voter turnout was 44%. In Kakamega, with a national tally of 65.4%, the total number of voter turnout was 57%. Simple mathematics, even saying that the figures we have are correct. And that is where we've come from, because there was a submission that we've not shown anything. Those two counties were way below the national tally. Whose strongholds they were is not my problem. All we are saying is that there was suppression and therefore voters were disenfranchised. You're cancelling an election at 8 o'clock at night on the 8th for voters the following day. You can imagine the confusion. And what was the reason for the confusion? A mix-up in ballots. This is all in our petition. I am just speaking to your lordships because if you read the petition, all the annexures are there. Oh, sorry, oops, we made a mistake in the ballot papers. There was a mix-up. Yet, there was supposed to be gazettement. A replying affidavit by the CEO, and it was supposed to be done by the 1st of July, a replying affidavit put in this petition by the CEO. Oh, we gave it to the national printers, the government printers, but they didn't print it, and so it should be deemed as done. There are news articles saying 128 ballots came to this country with ballot papers on the 7th of July, 6 days after this gazettement, or 7 days. And it is quite clear that there was an issue with the gazettement. It was backdated. But 128 ballots were already there. And the chairman admitted it, that there was a problem with the machine at the government printers for the printing. Even if you assume that it was printed on time, it was sent on the 1st of July. The earliest it could have been done was on the 2nd of July, because they haven't given us a time. We are voters, we are just watching this. We're watching this drama unfold. That being the case, and on the 7th, 128 ballots came. That's a lot of ballots and a lot of ballot papers. Nobody checked, like I keep on saying, 30 billion shillings later, we can't get an election right because there's a mix-up in the ballot. And therefore, my ladies and my lords, what is happening here is not a way to have an election at any level. We don't know what is going on as voters. People who are listening to this are getting even more confused as to what is happening out there. Was this accurate? Was this verifiable? It's our humble submission. The commissioners who came out, the disconnect between the commissioners shows that there is a problem. Mr. Chebukati says it is verifiable and accurate. The voter, what does Mr. John Joroge know? The commissioners are saying it was opaque. Where does the voter go? Has everybody forgotten the voter in all of this? The political parties are saying, I won, I won. We want to know what happened to our vote. And where we are today, we actually cannot say that where this vote went and what happened. And in view of that, it's my humble submission that one, the petition be allowed as prayed. And there is a prayer we've requested for, that there should be a nullification of this election, because the sovereign will of the people has not been, well, like I said, what we see. Whilst this court says an election is a process, for me, and even as a lawyer, and for Wanjiko and for John Joroge, an election is an event. You're going to the ballot, you're going to cast your vote, and you're hoping that your vote counts. We shouldn't be in a position where we hope that our votes count. We should be in a position where we know our votes count. And whilst there is a prayer which your lordships and ladyships might tell me off about, we have requested that the chairperson be prohibited from conducting any further elections in view of his behavior and or holding any public office in Kenya in breach of Chapter 6 of the Constitution of Kenya. The reason why we've said that is, unfortunately, whilst we created independent offices, we forgot about Chapter 6. And I think this court needs to show the way, even if it's to the lower courts or subordinate courts, show them the way that it's Chapter 6 that is going to be a question of integrity. In view of that, my ladies and my lord, I have nothing to add except if anybody has any questions, and please, can there not be hard questions?
Thank you very much, Council. You have donated to us 7 minutes. Thank you very much.
Thank you.
For your Janam. I think we will adjourn. Yes.
Was there something about the 12 visitors?
Yeah. 2 o'clock. 2 p.m. Yes. We will adjourn until 2 p.m., but before we do so, I recognize that we have observers who have joined us. Yesterday, during the pre-trial, we formally recognized the observers, but I think they were not present. So on behalf of the Supreme Court, my sister and brother judges and the entire court, we wish to welcome all the observers, especially the delegation from the Commonwealth that is led by our retired Chief Justice from Tanzania, the Honorable Justice Adhman Mohamed Chande, for taking time to come and observe